your part, go there and do that. You start the conciliation proceedings. Conciliation proceedings do not result in a finding or any settlement. Within 3 days, you pass an award without taking any counterclaim, claim, anything on record. And this is not complete non-speaking order.
My lord,
kindly such an order will be even struck down, even in execution. Sorry, next case, please.
my lord, kindly see the,
next case.
Award of the award. Kindly see the award. You will come to the page 1.
We have seen that.
My lord,
next
humble request is to come to page 145.
Please, we have discussed it. That's it. Next case.
My lord, kindly direct to be the MSME to be.
Please move there. Please move there.
They are my lord, but they are not
It
taking.
is open to the petitioner to move to the council for disposal for decision of the arbitration case in accordance with law. What is the arbitration clause?
The arbitration clause is at page number 23. That's the amended clause.
Does the International Chamber of Chamber of Commerce and Industry in Mumbai have an international commercial arbitration tribunal?
Well, it doesn't refer to the. I'll have to find out, but this doesn't refer to the international chamber in Mumbai.
Please come to page 51.
Yes, Manoj.
Page 42. Page 42, clause 10, arbitration clause.
That
Should be settled in the International Arbitration Tribunal in the Chamber of Commerce and Industry in Mumbai. What do you mean? It doesn't say so.
This was amended. Can I just the amended?
Which is the amended clause?
That's at page number 23. Starts at 22.
Yes.
Then at 23. Clause 10.1 of the contract should be worded as follows. The parties will take all measures to resolve all disputes, controversies which may arise out of or in connection with this contract by negotiations. All unsettled controversies arising out of or in connection with the present contract should be settled in International Commercial Arbitration Court at the location of the applicant. It's not happily worded, my lords.
The law of which country is applicable?
Law of India.
Next, below that, my lords, the contract comes into force from the date of signing. The terms of the contract regarding payment guarantees are valid so and so. But now the amended clause does not disclose which law will be applicable.
So what you have not amended says substantive law of India apply.
It says Indian law.
That says Indian law.
That says Indian substantive law of India.
Clause 10.2 has not been amended.
10.2 is not amended.
When it comes for the petitioner states that the amended clause 10.2.
That 10.2 is also worded as
Sorry,
follows.
10.2 is amended.
What does it say?
But you've not
It is silent from
referred to
the
what the governing.
substantive law.
Where was the agreement signed?
The agreement was signed in Russia. However, my lords, the place of the arbitration would be on the basis which party invokes. I am the first party to invoke. After I invoke, my lords, in fact, there is also an order, my lords. There is also the Bombay High Court in Section 9 has restrained the respondents from instituting any arbitration proceedings or continuing with any proceedings.
How can that be?
Lords,
1 minute. How can Bombay High Court do that?
what happened is,
Then 1 minute, please. It's a anti-injunctions, anti-suit injunction
yes, my lords.
or anti-arbitration injunction.
Because
What do you have to say?
your lordships have already protected him, your lordships, and he's cooperating in the trial court, your lordships. And the complainant is not even appearing here, your lordships.
It is not our business. That is,
I would only beseech my lord, just confirm this order, my lords, the whole matter would come to an end.
no.
My lord's order of 12th of November 2024.
No, why did you not appear earlier?
Well, that's because I had moved the High Court, my lords, and then High Court protected me. High Court had protected me, and subsequently, my lords, when the High Court rejected the anticipatory, I moved this immediately, I moved this court.
Even if you were protected, it was your duty to just inform the
Yes, my lords.
court and then.
I'm not saying, my lords, but ever since, my lords, after that, my lords, complainant is not appearing, my lords, no headway is taking place. And my lords, the presiding officer stands, nothing is moving. And therefore, under these circumstances, that's why, my lords, I actually got all the orders of the trial court, my lords. I got all the orders, in fact, my lords, attached along with the affidavit, my lords, the additional affidavit. So therefore, my lords, I beseech my lords, kindly, in fact, protect me so far as this order which my lords have passed while issuing notice. And then, my lords, the trial, I am cooperating in the trial, my lords. I am cooperating wherever the dates are fixed. Not a single date, my lords, I have been absent thereafter.
No, your presence is also not noted.
Yes, my lords, it's noted, my lords, everywhere. Kindly see, my lords, the last 3 orders at page 12 onwards. 2nd January 2025, sole accused files Azri. Then, my lords, 6/1/2025, again I am present. Then, my lords, on 11/2/2025, I am present. Then, my lords, on 3/3/2025, I am present. Then, my lords, on 28/3/2025, I am present. Kindly see the last order, my lords. It's very clear, my lords.
The complainant?
No, your lordships.
Please appear.
He is not appearing in the trial court as well as Supreme Court.
Is she served? Is she served?
Yes, my lords. In fact, the second respondent, my lord. Yes.
Leave granted. The appeal is directed against the appeal order dated so and so passed by the backward of Judicature Act.
Possibly the citus may be Russian. We are not commenting about it. We are commenting about it, but not pronouncing on it. But you'll have to check up the case law.
You consciously remove the governing law being Indian law. You removed that.
It was removed.
There needs to be some implication to that also.
It was perhaps not intended based on which party is aggrieved. That's why, my lords. I follow what is falling from your lordship.
That will have to be examined.
Yes.
That will have to be examined.
Obliged. Please, yes, my lords, we have already circulated a letter in this regard.
There is substantial delay in preferring the present special petition. Even otherwise, we are not inclined to interfere with the appeal order. Hence, the special petition is discussed on the ground of delay as well. Hence, the application for condemnation of delay and the special petition are discussed.
Obliged.
If you pleaded chief of army staff and whatnot,
They were the parties in the original petition. I'm not interested actually, sir.
not this.
Even if the ASG comes and says we'll pay, I'll be happy.
Go for the jugular, things might start functioning.
I don't want to go. I saw that we don't want to involve them at all.
You could have imputed this Sharwan Ram who writes this letter.
That's all. If you have not impleted him, have you? You're not, and you have to implead people by name. You can't implead like that. In contempt, I don't know how they have.
Allowed it.
Yes.
May I request for order
Oh, no, you have impleaded them by name
and agrees to
and are not impleaded the right person.
the people are the same as in the
No,
petition.
I know, but then
The name should come.
no names are there. In fact,
Names are there.
names are there. I saw the wrong memo, probably the memo parties as it was in the original petition.
I don't want to trouble anybody, my lord. Somebody
Right on.
can come and tell your lordship and settle the matter.
Issue notice, return it to the week commencing 13th of May 2025, notice to be served by all modes, including Dusty. Full stop. We clarify that notice that respondents need not appear in person. Full stop. Need not appear in person as full stop. Further, the petitioner is directed to plead. That's a PIO. What's the name of the Lieutenant Colonel? Name is Dr. No, this. Okay, why copy? To plead, Shravan Ram, Lieutenant Colonel Shravan Ram, who had written the letter dated 5th October 2024 to the present petition. Notice will be served by all modes, including custody.
This will not custody.
When was the order passed by us?
20th of March last week.
That's good.
Great.
May I please draw
There's no assurance given. It's a statement made in the court. How can it lie?
Yes, my lord.
Contempt will not lie.
My lord, just bear me for a few minutes.
How will contempt lie, please? It's not a direction given by or an undertaking
There
given
was
to
a
the court.
direction, my lord.
It's not a direction, sorry, you're wrong.
My lord, I'll read the direction.
Read that direction.
I'll read that direction. Your lordship may just have a look at, my lord.
I've read it. It's a statement made that they will. It's a statement made which we have accepted, taken it on record, but not fixed any timelines either.
Timeline was not, but it was as early as possible and at the earliest, my lord.
Look, these are political issues. These are also several things which have to be taken into consideration. That's it.
Your lordship may just.
We're not going to.
Your lordship may just have a look at para 50.
We have seen that.
Let them
Sorry,
come forward.
sorry,
Were they conscientious, my lord, in making this?
Sorry, please.
Oh.
Sorry. Next case.
Else I'll withdraw, my lord. I'll withdraw it.
Let it, after some hearing, let it ask for Mr. Six Partnership to withdraw the present petition in view of the statement made. Each is dismissed as withdrawn.
130
9 minutes. Item 9 minutes. It has been dismissed.
Number, follow the same order.
Same order minutes. I'm grateful.
My lords, this petition seeks. My lord.
And item number 10.
My lords, this petition seeks redress for a serious issue of discrimination, my lord. The denial of testamentary freedom.
There's already a writ petition pending over here, which is
Yes, my lord.
number 135 of 2024.
Yes, my lord.
It's a similar issue.
It is similar, but it is not the same, my lord, because the writ petition which is pending, they are asking the remedy renouncing from the community, renouncing from the Muslim community. But what I am seeking for in my petition,
Petition civil number 135 of 2024.
yes, 135/2024, my lord.
Versus Union of India and others.
My lord,
Notices will be served by all modes, including Dusty.
my lord, may I say one thing? My lord,
My lord.
Your lordship was pleased to tag with the petition one. I am the advocate on record in the other matter. There's a slight difference. There the lady has left the faith and she wanted to be governed by Indian Succession Act. Here the petitioner is praying that he still believes in the faith and he wants to be governed by it.
That is fine.
Yes, there is another specially petition pending, Quran Sunnat Society from 2016, 9534. So there both the believers and non-believers are there. Their claim is that the Sharia in as much as it discriminates women is unconstitutional. That petition, that specially petition.
We'll see that, let it come up in that petition, then when it comes up for hearing, then you can ask for tagging of the special petition. At this stage, just one.
My lord, can it be tagged along with 135/2024, my lord?
Yes, we have done that. We have done that.
Thank you, my lord. Thanks, my lord.
At this stage, Mr. Vishal
Prashant
Badnanabhi,
yes, ma'am.
advocate on record,
In 135.
states that there is special that specially petition number
9534 of
9534
of 2016.
of 2016, titled
Quran Sunnat, my lord, it is 9546.
9546 of 2024,
No, sorry, 2016.
2016.
Titled Quran Sunnat Society.
Just write it on a piece of paper.
Yes.
Raises several issues which are similar in nature. Full stop. The aforesaid specially petition will be also tagged and listed along with the writ petition, along with these three.
God bless.
Item 11.
Sir, Gauri Shankar, party in person, item 11, joining on video conference.
Yes, please. Mr. Gauri Shankar, go to the High Court. We will not directly entertain it. We have some reservations also on whether you can go into economic policies, because the government of India, when they, or the railways, when they introduce a Tatkal scheme, they also take into account that the fares otherwise are sometimes below the actual costs. So they have to recoup some money somewhere or the other. That we will not go into, because the actual cost per passenger is quite high. The freight rates are in fact subsidizing passenger fares. If you want to go to a high court, you are welcome to. Otherwise, we will not entertain it.
Say something, Mr. Gauri Shankar. I don't know whether he's able to hear.
He must be able to hear. It must be not anxious. Should be fine. The ones probably anxious.
My lords, it's
What a stand.
my lords,
Hats off. Hats off to Bharat Heavy Electricals Limited and the stand taken by her.
my lords, it's the
You appointed the arbitrator.
Sorry.
You go before him and say you have no reservations about his integrity. And once he passes an award, you say no.
Dismissed with
But
costs.
my lord-
Should be dismissed with exemplary costs.
my lords, may I just make one submission? Our opinion is now not, my lords, it cannot be.
So your opinion changes and we at the other litigant surface. Sorry, please.
Your lordships just.
Sorry, please. You cannot raise that objection. The other side could have raised that objection.
My lords,
Sorry.
the Delhi.
In our opinion, the present special petition is entirely misconceived as objection to appointment of the departmental arbitrator should have been raised by the respondent and cannot be raised by Mrs. Bharat Heavy Electricals Limited. So specially petition is.
May I have
Not that your departmental arbitrator is so unbiased and detached. You should in fact promote him.
my lords, the difficulty is, my lords, what happens if we can't challenge the other side challenge?
Not
then-
victimize him by challenging his integrity now.
No, my lords, it's not that, my lords, but once your lordships have declared the law that ineligibility is attracted and there is the ineligibility in law applies. On merits, otherwise there is a remand, my lords, the merits will be considered. On merits also the award is.
That's fine. We are not going to that question. It's high time you stop this.
Leave it at that, my lord.
Create a mess The court sorts out the mess. You keep on repeatedly, in spite of TRF and other judgments, repeatedly you raise that pleas. Now it's sorted out. Now you come up after the arbitration is held, everything has taken place, goes against you. Now somebody in the legal department says, let's take an objection to our arbitrator.
My lords, would your lordships then consider, my lords, passing a detailed order on this?
No, please, we have passed a single line order, that's good enough. If we pass it, perhaps what is required, even if we have to set aside an award of this nature, probably we'll have to burden you with enough costs because you've made the other person suffer so much.
My lords,
litigation.
what I'm respectfully submitting is if your lordships, I'm not on your lordships' view, your lordships have taken a view, but then kindly say that, would your lordship consider saying that it is not only because we have appointed, because the arbitration has concluded. So that, my lords, then both sides are foreclosed. It can't be that because...
We'll see. Let's guess. Dismissed.
My lords, the repercussions will be on other cases also. So if your lordships clarify... if your lordships clarify on appointment and...
We are not going into that question. That's
great.
Just add one. Further, no objection was taken by the petitioner to appointment of the arbitrator.
Even during the hearing?
Yeah, during the course of the hearing, the hearing in the arbitration proceedings.
Please, my lords. That at least will apply to both sides, my lords. Otherwise, when we will, they will come up, my lords. Grateful, my lords.
Please, my lord, this is a fresh section 11, my lord. The petitioner is a 94-year-old US citizen. My lord, both the twin conditions, my lord, of the arbitration clause and section 21 notice having been sent, my lord, both are satisfied. In fact, my lord, the Bombay High Court
issued notice returnable in the week commencing 4th of August 2025, notice to be served by all modes, including justice.
My lord, can I just request for a shorter date? My lord, he's a 94-year-old man.
We are aware, but it will take some time. The response will file their reply within 4 weeks of service. Rejoinder may be filed within 4 weeks after service of the reply.
Grateful.
Your Lordship, it's a private water body, and Your Lordship, the respondent has failed to produce any material evidence on record.
That will be examined. You make a representation. How will the court going to know? You purchase the land which is filled out with water, and now you say,
Your Lordship, but
please vacate that, take out that water. Sorry.
Lordship, very small submission, Lordship. If we
cannot pay, we cannot entertain one.
Please, Lordship, because this is the matter of Lordship survival, Lordship. There is a private property and nothing has been changed in that existing.
Sorry, go make a representation.
Lordship, even the locus standi, Lordship.
Trying to interfere with the accused judgment and especially.
Lordship,
sorry, please.
If locus standi doesn't.
Please, sorry. Go before the authorities.
Lordship, competent authority already is just pressurizing Lordship without proving any documents, without.
Next, please. 15 is the same NHA. Move before the civil court if you have to, if the authorities do not act, that's it. We don't go through all these questions and everything.
Lordship, then will you withdraw the Lordship, please?
In item number
14, Lordship.
Comes for the petitioner seeks permission to withdraw the special petition.
Liberty to.
No, we are not giving any liberty. That's already mentioned in that order. We have the statement made, special petition is dismissed with withdrawal. 15, same order.
May I find out if this is infructuous today?
What is this? 20% is not mandatory.
But we might have.
And let me put it, 69A is being abused these days by the revenue. Anything which comes, look, there are so many donations received by most of these charitable trusts, which will be in cash.
We have no difficulty, but our request is please file a return. This particular has not filed a return for the relevant.
It does, but you have made an addition. Why did you make the addition?
So instead of my lords would have it next week, this might have become infructuous, my lord, because we would have passed the assessment.
No, nothing. The only question is deposit of 20% or not. And 20% is for the In case you deposit 20%, the assessing officer passes an order. And that cannot be a thumb rule. Additions are made. Sometimes justified additions are made. Sometimes there are additions which are not justified. The appellate authority equally has the power to set aside. And there is no statutory provision.
So this is imposed in all cases. This is a special case where they didn't find not any information.
Says 20% cannot be made a thumb rule. You're wrong on that. When the assessing, for the administration purpose, you have said the assessing officer has the power not to enforce a demand. You first said 15%. Somebody said, let's collect more taxes. You made it 20%. Fine. But that cannot bind the court or the appellate authority.
My only request, Malad, instead of dismissing this matter.
We are dismissing it. That's it. Special petition is dismissed. Next case. Delay in process. By now, the appeal should have been heard.
Hence my request.
No, but you know the number of appeals pending before the CIT appeals?
That's also hence my request.
5,50,000 appeals are pending before CIT appeals. 5,50,000. Not inclined to interfere in judgment and especially petitions. Next case, please.
Great.
Forward
orders, my lord, one appeal is already dismissed. But same order may be passed.
Okay, same order.
Yes, delay of 2 extent. Delay may be condoned.
Please, my lord. Please, Lord.
Yes, please.
110 days delay.
Why before I am allowed?
610 days delay.
Lord, the report of the handwriting expert has not yet been delivered, submitted in the court of Third Judicial Magistrate, Malda, my lords. Hence, the present proceeding is going on. There is a money suit.
On the application for condemnation of delay, as well as especially petition returnable in the week commencing 11th of August 2025. Notice will be served by all modes including trustee. Stop. It is submitted. This is a clear case of abuse of process as the respondent complainant had not succeeded on earlier 2 occasions. Stop. He has taken benefit of the terms and conditions of the agreement to sell by as flats have been allotted to him.
A DD has also been given.
Till the next week of hearing, there will be stay of further proceedings before the trial.
Grateful, my lords. So grateful.
Let's see.
This is that case, my lord.
FSL report.
Learned solicitor is leading us, my lords. If there's a request, if it can be kept next week, my lords. There's some report.
Report is ready.
And the learned solicitor will make the report.
At least have to tell us whether it's ready or not.
Apparently, it has.
For that, you need the solicitor to come and tell you.
Yes, ma'am.
It's ready.
Yes.
You don't want to share it with us.
My lords, it will be shared, my lords.
Okay. This stated that the report has been received. Rest in the week commencing 5th of May 2025.
Right.
This matter, let it go before another bench. We will not be able to. This will require some time. But
well, this is only that.
That's it. In the compromise?
No, they never even contacted us.
Lord, my learned friend's client filed 4 applications before the executing court. And my lord, we've still worked out various solutions, but I think, my lord, your lordships may have to hear it, because even to request your lordships to accept any of the solutions.
We missed it before. A bench presided over by Honorable Mr. Justice Pandiwala in the week commencing 5th of May, 2025. You have the original documents with you. Good.
No, may I just point out,
That's first.
Yes.
This is the.
Yes, ma'am. No, Milord. In fact,
you are in big difficulty.
Yes, your lordships are right to that extent. Now, may I just show one document?
You have messed it up. You have deliberately taken so many.
Can I only make one request if your lordship may consider it appropriate? Only see the seizure memo issued.
That seizure memo is, let's say, the better.
Because they are, in fact, police has filed a counter against me, so your lordships cannot.
No, sorry. They have changed the stand after the court's intervention.
I know. Because from day one, I have been.
Go back. This bail has to be set aside.
Will my lords, at least when your lordships are remanding back, can I only make.
No, remanding back. This bail order has to be set aside.
Can I only make one request if your lordships may consider it appropriate?
They cannot pay. Yes. It cannot pay. That seizure memo is done at your behest.
No, I'm saying one thing, Milord, only consider. Milord, may give me liberty, only 1 week's time to bring those documents here.
Sorry, nothing.
Yes,
sorry.
Please send.
No, we've given you enough time.
No, I'm saying something else, Milord.
This is a completely a fraud which has been.
Can I make one request?
Once the original documents are with them.
Your lordship, some documents have been shown to your lordship.
That's it. We require the original trust deed and original sale deed.
Yes.
You are a businessman. You're dealing with real estate. You know what is the value of the original document.
Yes. Can I only make one request now? Let state be directed to bring those seized documents and.
Sorry, we are not going to do that. The state will never get those.
No, because we have handed over with them. If they do not exist, your lordships can pass.
Sorry, please. You would have got the photocopies. Please place those on record.
Photocopies?
Yes.
Will you give me 2 days?
No, you should have done it by now.
May I say this?
No, I'm sorry. You should have done it by now.
Can I only make one request? Because today I go with the presumption your lordships are right. I am saying your lordship.
There's no presumption. We know that.
Your lordships are saying that the document issued by state is a false document, wherein they are saying they have taken original from Lakbir Singh. Today our presumption is wrong. I am saying let the officer be called to bring all the documents.
Sorry, please. Sorry, please. This order cannot be sustained.
They are already sent to FSL. Please call them back. Why could I not bring these documents today? Because they are in line with FSL. Please call them. If your lordships find those documents are forged, which are my Lakbir Singh has, then your lordships may pass.
Sorry, please. Right now, leave granted.
Can I only make one request?
Leave granted. On the last date of hearing, he had called upon the petitioner, Ekjot Singh, to produce the original trust deed as well as title documents. Stop. The second respondent, Nitin Ketan, was also directed to file an affidavit regarding original documents of title and the trust deed. Next page. Today in the court, the appellant, Ekjot Singh, has produced the original trust deed.
And you also have a look at it because
you can have a look.
Because we have to see whether they are the documents which are original of those which are the title.
Original trust deed dated 14th January 2002, which is duly registered. He's also produced copy of this original sale deed dated 16/1/2002, which is again duly registered. You can have a look. The registered documents also have photographs and stamps of the registering authority. given the reply given by the second respondent.
Now we'll see. I have annexed a seizure memo, which
I'm referring to it.
Yeah.
I'll be referring to it.
Yes.
You'll get the answer, and that may affect your trial now. That may be separate, but I'll deal with your argument.
Because who has submitted that seizure? The person who has sold.
Correct. Because he's hands in gloves with you.
No, there. Can I only show one document?
1 minute, please.
After this.
The second respondent. Nitin. Ketan, in his affidavit, states that the original documents were taken into possession as a part of production memo on 9/12/2024 from you or Lakhvir Singh?
Lakhvir Singh.
From
trustee.
From Mr. Lakhvir Singh. The alleged trustee with whom the second respondent, Nitin Ketan, had entered into transactions. Full stop. Next paragraph. Once the original documents have been produced before us, we do not doubt the case set up by, we feel that the case set up and the facts stated by the appellant Ekjot Singh are correct. Full stop. It's not understandable why Lakhvir Singh, by Ms. Lakhvir Singh, would have furnished the said original documents, when they are available and in custody of the appellant Ekjot Singh. Further, it is a case of the second respondent that he is a purchaser who had acquired rights in the said land from Mr. Lakhvinder Singh
and Jasveer Singh.
And Jasveer Singh, then being a builder, he would have taken into custody the original documents of title.
Yes, not a CLD. My ATS says that I will pay them when my CLU comes. That agreement also I have annexed with my affidavit. All paid.
In fact, that's fine. Obviously, you'll do it when you're camouflaging.
No. Money has gone to trust and Jasveer Singh collectively.
1 minute. Jasveer Singh trust is sham.
No. May I understand?
Absolute sham. Next page. As per the FIR, the trust, namely
charitable trust.
What's the name of the trust? Anubhav Charitable Trust is the owner of land bearing number bearing khata number 14/14. Just copy that at page number 88. I've underlined that. And measurings 49 kilas, 9 barlas. Stop. MS Rajmohan Kaur is a trustee. Stop. She claims that she has not executed any documents for transfer of for deletion of a name or for transfer of or for induction of new trustees. etc.
Resignation, because she denies her signatures on the resignation of 2021.
She denies her signatures on the documents relied upon by the second respondent.
No, not by me. Milord.
1 minute, please. You are relying upon the documents. Obviously. Relied upon by the second respondent. Nathan, who however claims that he may have, that he is himself, that who claims that the said documents were relied upon by Lakbir Singh and
Milord, only Lakbir Singh, and there are two other trustees.
Lakbir Singh. Full stop. It is a case of the however, it's a case of the prosecution that Lakbir Singh and Nathan Ketan are cahoots and have indulged in the above forgery to grab the land belonging to the trust. So stop. Next paper. In view of the aforesaid position, we feel that the High Court, that the impugned order passed by the High Court is not sustainable, and hence we allowed it as an appeal. Full stop. You granted anticipatory bail?
Yes.
The application for pre-arrest stroke anticipatory bail in FIR number 510 dated 24/12/2023, registered under sections 406, 420, 465, 467, 468, 471, 120B of the Indian Penal Code, registered at Police Station Sohana, District, SAS Nagar, to be treated as dismissed.
Can I only make one small request if your lordships may consider? Your lordships may only have 1 page of my additional affidavit. What I am saying is, because the documents have been submitted for FSL. The police says so. The originals given by me. Only just look at that document. Because her signatures on resignation have been sent to FSL.
Please, if the original documents are with her, that's it.
Can I even have a look at it if these are the...
Please look at it.
Because no,
that we said, please have it.
Okay, because they did not. No, because the police is saying that the originals are with...
Please, we also understand what has gone on.
Your lordships, can I make one request? Because in case your lordship says that police has taken original from me and then handed over to them, it will cause...
Sorry, I've not said that.
No, I'm saying...
I've not said that.
In this case, your lordship only...
Now you got to that extent, you've cudgelled up a new story. You have not even said that and you can't cudgelled up that story.
If this document is false, then the state has issued...
1 minute, please. It's very unusual. Look, why we are saying that you are hands in gloves and cahoots with them, like we are saying. You are a seasoned businessman dealing with real estate. Correct? You're not a novice or a layman looking around for buying a plot of land. It's a trust. The trust was owned by so and so. You also accept. Lakwinder Singh, you say, comes and says, I have become the trustee. She resigned and she transferred the rights in it. Correct? Lakwinder Singh, you would have asked how much money did you pay her? But we don't want to tell you all that. You don't go into all that. You don't take the original documents in your custody. You make payments by check and then you say, I made payments by check at a lesser amount because the property there's some dispute going on in the property, so the market value is much higher. Second circumstance against you. I could have recorded all these.
I'm sorry.
I could have recorded all this. I've deliberately not done. Otherwise, you would have been in a greater problem. You get it? Now what you do is, after the FIR is registered, Lakwinder Singh says, I'm giving these documents to you. You don't give the documents because you want to show that there's a gap between you. It's not it's an arm's length transaction between you and Lakwinder Singh. On the other hand, indications are Lakwinder Singh has been put up by you. Money has gone from your pocket to somebody who's his hands and gloves with you. That's it. It's not, nobody in business will take it for a night like that. Sorry, next case, please. No, sorry, dismissed. Your bail application is dismissed. Yes, certainly. Is it a problem?
Can you Lord at least give me a liberty to file afresh?
Sorry, please. No fresh application. No fresh application.
This will amount to my clients.
Obviously, he's going to be in a problem. Whether they arrest him or not, we have not given any directions. If they find material, they will arrest him. We have not said anything. But the anticipatory bail cannot be granted. Next case.
Case, I'm not appearing, but he is also someone who has been accused in the same FIR. So, I'll have to be here to see his 22.
Yes.
In fact, based on his order, I was granted anticipatory bail.
My lord, he is the person about whom we got to know during the process we filed an FIR against him. He has done it earlier in 2016 by forging the signature of Mrs. Rajput Kaur. He has not made any resolutions per se, but he has signed off a forged consent.
Yes, please.
Please, Lord.
He's been also granted anticipatory bail.
My lord, he has been granted anticipatory
bail. My lord, I am for respondent number 2, my lord.
Yes.
My lord, the sole allegation against respondent number 2 is that I got the CLU on the forged documents, my lord. Whereas I'll just take my lord, for a moment. P3, my lord, page 30. Para number 9, 10, my lord. That clarifies the fact, my lord, all those documents which they now say that.
21.1. Yes.
Please, my lord. P3, my lord. Page number 30. For a moment, my lord. Para number 9.
Page number
30, my lord. 30 of the petition they have filed, my lord. Page 30, my lord, para number 9 of MOU.
Yes.
My lord, here it is clarified, but that time, my lord, these all documents on basis of which they are saying that I got the CLU in my favor by forging the documents. These all documents have been provided by my lord Sherwood Society, and later, my lord, these documents are all on the basis of these documents. After getting CLU, my lord, rather expenses which I have, my lord, incurred to me, my lord, are of 2 crores, my lord, for getting that CLU.
No, I couldn't understand. I couldn't understand the later part what you are arguing.
My lord, to get that CLU also, my lord,
in 2016, this builder purchased this from this society and trust collectively because you need at least 25 acres. 6 acres is with trust, 19 is with Sherwood. So in 2016, this builder entered into an agreement with society and Sherwood in 2016 applied for CLU, not CLU granted. Later on, since he could not pay for 25 acres 8 years ago to society and to Sherwood for 19 acres and 6 acres, the CLU was cancelled, and then in 2022, I stepped in, I paid Sherwood and I paid the society to do this transaction. So the documents which they are alleging, Rajmohan Kaur says that even in 2016, whatever documents were applied to, I did not sign it. So now all these documents have been sent to CFSL of 2016 and 2021 with admitted signatures of Rajmohan Kaur to verify her.
1 minute, please. What is admitted signatures? She is not admitting those signatures.
No. The admitted signatures for purpose of CFSL is that the police tells her that you sign, give me your specimen signature.
Okay.
We will take it from
specimen signature.
Yes, her specimen signatures have been taken, and all the documents which she is saying is forged has been
again, you did it in 2016. You had applied in 2016 for getting the clearance.
On the basis of documents, my lord, which were provided by the Sherwood Society, my lord. By the directors of Sherwood.
Why will Sherwood Society provide the documents relating to the trust?
Because my lord, if my lord will see, my lord,
Why
the
will
reason.
Sherwood Society to provide documents belonging to the trust when the Sherwood Society is not the owner of that land?
No, my lord, they were, my lord, of 12.5 acres of land, my lord. They were.
That's a separate land. That's a separate land, not the trust land. Why will Sherwood Society give you that? That's on the face of it. Your plan is on the face of it is very weak.
Please, ma. If my lord will see why they have provided me those documents, my lord, I have a reason for that. I have a reason for that.
Why
they have
will
provided me
Sherwood
those documents?
Society provide you documents of title relating to a third person? There nobody gives the original documents of title to anybody. They are very precious.
My lord, because if my lord will see, my lord, that as per the as per section 5.1, my lord, 5.2 of Punjab.
What Punjab is a question of fact, not a question of law here.
Can I answer that?
That is there.
Only a consent is required. Original documents are consent that we have consented that this builder will take license, develop and later pay us. Only consent, one page letter is required with photocopies of the documents. Originals are never to be submitted to the authorities for taking CLU. So in 2016, two societies together applied by giving consent. Then they had a fallout with this builder.
Sorry, this is also right.
But rather, I am one of the victims. My lord, who applied
documents of title. That is the trustee. Copy the first paragraph. And the sale deed, original sale deed have been produced before us. So stop. We have also elaborately dealt with and answered the bail. Examine the question on the grant of expiatory bail to litigated in the connected appeal and allowed the same cancelling the expiatory bail granted by the High Court. Observing that this is prime facie, a case where documents were forged to acquire and show possession of land as a result of conspiracy. Full stop. Let's go. The second respondent in the present case, namely Kavaljeet Singh Ahluwalia, had in 2016 applied for change of land use from the Greater Mohali Area Development Authority for a real estate project. Stop. The case made out by him that he had obtained and seen the original documents which were shown to him by Sherwood. What's the name of the company?
My lord, this is Sherwood Society, Officers Society, my lord.
Sherwood Officers Society, prime society, does not appeal to us for the reason that the said society was owner of a different portion of land, whereas the trust it is accepted. The trust, namely Anubhav. So is owner of the land measuring 49 canals and 29 marlas located in sector 113 SS Nagar, Mohali, Punjab. The value of which is stated to be between 40 to 50 crores. Stop. In view of the aforesaid position, we set aside the appeal order and allow the present appeal. The application for arrears stroke anticipatory bail filed by the second respondent However, 6 Aluwalia will be treated as dismissed.
Deeply obliged, Your Lordships.
Grateful, my lord. Can I only point out one more thing, my lord? There are other identical orders in the same matter annexed as R1 and R2, my lord. It's not just us, my lord. In fact, my lord, there are many.
We'll see when they come up.
There are allegations from 2010 onwards of forgery and no action taken against anyone from them, admittedly after receiving money from everyone.
Next case.
Obliged, my lord.
Please, Your Lord.
Will not only say, my lord, finding tendered in this order will not come in our way, either for, my lord, any application we make in the trial court, either for regular bail or, my lord, otherwise.
The finding is recorded in this order will not be treated as binding observations in the trial of the proceedings. During the course of trial of the case.
I'm obliged. Deeply indebted.
May it please, Your Lords. This is the matter, my lord.
Yes, please.
My lords. This matter, my lords, my submission is the first, my lords, preliminary objection is that, my lords, the application, the order, my lords, out of which, my lords, the present SLP arises, is divorce any provision of law. For the reason, my lords, that the cognizance was taken under section FIR was registered 304, he did not challenge, he did not file protest.
Doesn't make a difference.
190
Judge has to, in fact, let me say, this talks about bias of the police.
But then
Bias of the police,
so therefore, my lords,
because it's a case of honor killing.
he's also been
And therefore, probably we'll have to ask we'll appoint a special prosecutor.
So, please, my lords,
My lords have already constituted an SIT, my lords, in the.
Yeah, no, this case charge has to be under 302.
Lords, charges
My lords may hear me. I only will make two submissions.
No, but that is, my lords, allow me.
Not incorrect.
What has happened in this matter, my lords?
SLP itself.
Cognizance taken, he is not challenged that order.
That is irrelevant.
My lords, 193
Court has the power to alter the charge.
But then charges, 27th of September, this order was passed. After that, 29th September, the order on charge was passed, and then he challenges this order, in the month of October.
This case of honor killing. Then the state government is not realizing that neither the police is realized, neither the courts have.
What I am submitting is that
just because they belong to different faiths.
Sees FIR. No, it is not about faith and
this is
he admits, that he comes to my house to besmirch my girl, That is what Milos see the FIR. FIR, he said that my son had gone to the rustic village to meet his friend at 11 in the night.
You see injurious, Mr. Divyesh. And that 14 and the hit is by rods in the court says it will be 304.
The Honorable High Court has given him liberty to file an application under section 216 and
sorry, the High Court should have interfered there and then. No, should have been sensitive to the cause.
Understand, what is going on in your lordship's mind, what has happened is that now PW1 has been examined.
No,
he can very well.
Chief is going on. Only chief is going on.
Go and file an application under section 216, Milos.
If there is anything. Right of leave granted.
My lords may also hear.
May I say, one thing, before your lordship,
we are appointing a special prosecutor in this case. Please suggest a name if you have to.
I can take instructions, my lords. My lords may give me 2 days, and if my lords will permit, my lords have expressed a view, which is clear. But if my lords will, without prejudice, allow me only to make 2 submissions. But in any case, my lords may give me 2 days for appointment of special prosecutor, my lords. For names.
We'll dispose of this special petition, and we ask you to appoint a special prosecutor to deal with the matter. This is a clear case of honor killing. You can't deal with it so lightly.
My lords, there are two respectful submissions if my lords will permit us to make without prejudice, my lords. My lords have categorically expressed a view. However, there are 2 facts. One, my lords, 26-year-old man found in the bedroom of 18-year-old daughter of the house at midnight.
But there are, look, you cannot like anybody. Is this a crime in the society if you like somebody?
We don't know.
Should they have to hide behind because they belong to different faiths?
Not at all, my lords, not at all. Just only for 1 second, my lords, from the family members.
There's no intention to kill. Somebody is beaten with sticks and rods, there's no intention to kill.
Only lathis, my lords, what happened?
That if someone is killed with sticks, there's no intention to murder. We record that and apply it across then.
That is not the submission, respectfully, my lord.
What you said in paragraph 8, Ms. Goyal.
Only the circumstances, my lords, from the family members' point of view.
Injuries and you say that does it amount to grave and sudden provocation? Secondly, even if it amounts to grave and sudden provocation, then you must not act. The action has not to be cruel. That's the second requirement of
Please,
the
my
third.
lords.
Is that, and that's the law? Is that the law?
We were only submitting regarding circumstances, my lords. It's a village, 18-year-old daughter of the house.
Because I have a right to private defense.
26-year-old man found in
Right to private defense is a defense at the stage of framing of charge. That will not be taken into consideration.
Have already given me enough intelligence. What I am submitting is that the stage has already passed. We passed that stage.
We have already directed when we passed the order, we directed that the court be conscious of the fact that we are examining this question.
But then the learned trial court has already examined PW1.
No,
And they
make a difference.
Only chief
And
has
want him to be recalled.
only he's making wrong
Chief has already been done.
my clients are being examined there. I know the latest position.
This essentially comes over here and tells us
I'm
soft
not
study.
right after earlier complaint.
Soft study. You say whatever you have to say.
Please
come over here and
don't argue with
me. Leave grants.
There's one more submission. If your lordship, because we were in custody for some time. Your lordship, if your lordship directed that 302 also be invoked, then may say that the bail which has been granted under section 304, we stand good also, and we were directed to execute our bonds.
Right.
Please.
Leave granted. We have examined the post-mortem report. Which records that the deceased what is the name of the deceased?
Ziaur Rahman. Ziaur Rahman.
Ziaul
Rahman.
Nay, Ziaul Deen.
Ziaul Rahman, my lords. Ziaul
Rahman.
Please, my lords.
Yes,
Ziaul Rahman.
Yes.
Age 26 years. Had suffered 14 injuries, which are as under. Suffered 14 antemortem injuries, which are as under. Copy from page number 30 to 31. The cause of death was due to shock and hemorrhage. Full stop. On the question of on the question of place of occurrence, as well as on the question of place of occurrence, there is no doubt or debate. Full stop. Next one. Learned counsel appearing for the appellant. Ayub Ali, the father of the deceased, submits this is a case of honor killing, wherein the family of the girl had beaten the deceased with sticks and rods with the clear intention to kill and murder. Full stop. He submits. This is reflected from the nature of injuries mentioned in the post-mortem report. Next page. We are a little surprised why the charge sheet was filed invoking section 304 of the Code of Civil Procedure, Indian Penal Code, sorry. And thereafter, at the time of framing of charge, the trial court framed the charge under section 304 of the code, simply recording page number.
The trial court judgment is page 83, my lord, and the relevant finding is page 85. The trial court says that since there are no firearm injuries, therefore 302 is not one. Page 85, my lord, bottom. As per post-mortem report, there are 14 injuries. In fact, I filed my application before framing of charge only, my lord. Page 74 is my application. Before framing of charge.
While recording that the deceased had suffered 14 injuries, yet the injuries were not caused by a sharp-edged weapon or firearm, but by sticks, etc. And therefore, case for framing of crime, there is no prima facie basis for framing of charge under section 302, read with section 34 of the Penal Code. Full stop. The appellant, Ayub Ali, in fact, had filed a detailed application, had filed an application that the charge should be framed.
Page 70.
Under section.
Page 74.
You had filed an application that the charge should have been framed under section 302, as the post-mortem report had also found that the deceased had suffered pleural hematoma on the head and left side of the brain, and parietal and frontal bone were fractured. Just copy this also. Your postmortem report is in fact incorrect.
The typing, they added
page
the
74
injuries. Yes,
you mentioned that.
He died as a result of anti-mortem injuries.
The death was as a result
page 20.
of anti-mortem injuries. Page 74 is there. So stop. On the contours of the aspects which the court must take into consideration while framing of charge, this court in Ghulam Hassan Beg versus Muhammad Maqbool Magre 2022 12 SCC 657 has referred to, has observed that the court, while framing charge, undoubtedly has the power to sift and weigh the evidence, but the same is for the limited purpose of finding out whether or not a prima facie case is made out. Full stop. When the material placed before the court disclosed grave suspicion, which is not properly explained to the court, the court would be justified in framing charge and proceeding with the trial. Specifically dealing with the question whether a charge should be framed under section 304 or 2. It is observed as under copy paragraph 33. Full stop. In this case, we find on the facts just above, the charge should have been framed under section 302 of the Penal Code and not under section 304, as has been framed by the trial court and upheld by the High Court. Stop. The impugn judgment is accordingly, the High Court and the trial court are accordingly set aside. The charge will be treated as, the fresh charge will be framed under section 302 of the Indian Penal, read with section 34 of the Indian Penal Code, and the trial will proceed accordingly. Full stop. The appeal is allowed in the aforesaid terms. We have clarified that the observations made in the present order will not be read as observations and findings of the merits of the case, but the trial will proceed in accordance with law, and on the basis of evidence and material, on the basis of evidence led during the course of, and the final decision will be on the basis of evidence and material laid before the trial court. Next paragraph. Keeping with the nature of allegations and the manner in which the trial has proceeded, we would require the state of Uttar Pradesh to appoint a special prosecutor after having a word, after speaking to Ayub Ali, the father of the deceased, to conduct the said trial. Most of the said exercise will be completed within a period of 6 weeks from the date copy of this order is served on the director on. There is a prosecutor's office in the state of Uttar Pradesh.
My lords, I'm not exactly sure, but we will, if my lord says 6 weeks, we will comply with that. My lords.
From the date copy of this order is served on the Chief Secretary, State of Uttar Pradesh. Full stop. The compliance report will be filed in this court.
Milord, may I say that the bail granted.
Milord, I have objection.
We also have clarified this order will not affect the bail which has been granted. But it will be open to the respondent number 225.
Private respondents plus 2 to 6.
2 to 6. The private, it will be open to the private response 2 to 6 to move an application for bail before the trial court.
Much obliged.
In view of the amended charge. Full stop. The said application for bail will be considered within a period of 3 weeks from the date of filing. Till the application is decided, the respondents 2 to 5.
2 to 5, please.
2 to 5 will not be taken into custody.
Not sure.
2 to 5, not 6.
2 to 5, yes,
2 to 5. Need not be taken into custody.
Milord, may I submit the trial court may independently decide that bail application?
The bail application will be decided on its own merits.
Much obliged.
Extremely grateful, my lords.
Please, plus the entire FIR has been washed with Honorable High Court Malone. Allegation that the officers are not implicated, the names are not there in the FIR. Lordship, may kindly see page number 5, Malone. It's coming after notice, Malone.
Yes, please.
Paragraph number 6, Malone.
Yes, what do you say?
Please, Mr.
How can this petition be allowed?
But your lordship may kindly say that.
There's allegations.
Two aspects, my lord.
Severe allegations. How can there be you question the FIR itself?
But no, what the
FIR need not disclose the name of the criminals or the accused. It's an offense which has been committed.
I'll just point out what is my. Well, this is one of the points. I had raised about 6 points before the High Court. High Court has considered this. So
what can be done?
No, but there are 5 more points also.
What is the 5 more points?
I'll just point out.
This point is certainly, look, there is forgery, there is wrong allotment of land. You accept that?
No, but dear lordships may kindly say allotment is made in 1999.
No.
Pardon?
Allotment is made in 1999. I was there from 2015 to.
That's right, but do not quash the FIR.
No, but your lordships may kindly see here there are 3 aspects your lordships may kindly consider, my lord. Firstly, so far as the question in this case is concerned, my lord, High Court has given a reason stating that it is actually a malicious prosecution, my lord.
What malicious prosecution? Can you say so in 482 when FIR is simply registered and they are making allegations that land has been transferred?
FIR is registered only against me, whereas there is no allegation against me.
1 minute, please. FIR is normally registered for a crime, even if the name is mentioned That is immaterial because if you're not involved, the prosecution will not, the crime will be, they will not be prosecuted. But as far as the offence is concerned, it is certainly made up. Court could have said, mere mentioning of the name of so and so should not be read as if he is the accused. The allegations are there with regard to forgery and transfer of land. That can be examined.
That can, against unknown persons, let them do it, my lord. No. But why I should be named, my lord? That is my
relevant period 2015 to 20.
Pardon?
The relevant period is 2015 to 20.
Not in 1999.
No, my lord.
No,
page 67. Page 67.
Right.
Specific allegation. Page 67, the paper book. Let's during the period from 2015 to 20. Misused the jurisdiction, created fake shelter plots and deeds under the government shelter scheme, created fake accounts, which is e-Khatha, documents not for the non-beneficiary persons, and did not make any of the accounts of the panchayat. They have an account on the cyber, which is e-Khatha. There is no records related to those documents available in the Gram Panchayat. Also destruction, the next page may go. Also destruction of the document with the help of the
take a case against you.
No, your lordship.
Specific case.
Kindly look at my counter because they have not produced.
Okay, let's see your counter.
Kindly look at my counter, my lord. First, your lordship will find annexure R1 which I have produced, which is Ashraya scheme, my lord. Your lordship will find it at page 13 of my counter, my lord.
Also, there is another FIR registered against officers by the Panchayat Development Officer.
Same ground.
Same allegation, same 21 plots.
And there was one issue,
I have produced that also.
It was filed in the Anti-Group Bureau Department.
It's not a case for caution.
My lord, your lordship may kindly see, your lordship may kindly consider, my lord, kindly come to page 13 of my counter, my lord.
We are passing a short order, not a long order.
But then in that
if you produce the allegations in the FIR, you'll be in a difficulty. You're simply going to say the court should not have gone into the cross allegations.
But in that case, your lordship may remand the matter because
no,
I have. My lord, kindly then consider my points, my lord, before your lordship.
Not required to be considered. You're not required to be heard.
I fall within the categories, my lord, which are set out in the.
Doesn't make a difference. Right now, our attention is drawn to the allegations made in the FIR. Number?
It's 67.
158 of 2021, dated
28/7/2021.
20.7 that 2021, page 65, registered at so and so police station under sections 420, 468, 465, and 471 of the Indian Penal Code. Next page. We have also examined the reasoning given by the High Court in the impugned judgment quashing the said FIR. Stop. In our opinion, the High Court judgment is unsustainable and should be set aside. Stop. At the stage of registration of the FIR, the assertions made therein have to be taken into consideration. Stop. The respondent number one. SG Suresh, GS Suresh, that meet the allegations during the course of the investigation. However, the High Court would not have by a short order scuttle the entire investigation itself. After observing, no doubt, there are irregularities, but the reading of the entire complaint indicates that the complainant wanted the first respondent, PV Ravi Kumar, to be prosecuted. Full stop. FIR discloses commission of an offence. Stop. once the said condition is satisfied, the High Court should not have quashed the FIR itself. To stop. The appeal judgment is accordingly satisfied that the appeal is allowed in the aforesaid terms. Stop. We clarify that the observations made in this order would not be read as observations and findings of the merits of the case or the allegations made to verify.
Liberty.
In that case, my lord, your lordship may kindly give me liberty, my lord, that in case
All
there is
fees and contentions available to the parties, that is the appellant as well as the first respondent, SG Suresh, are left open.
No course of receipt.
Next case.
well, no persistent will be.
No. We
But your lordship may kindly.
we are not giving any.
But your lordship may kindly consider, my lord, in
Are left open, fees and contentions are.
very same page which your lordships have read, my lord, your lordships will find there are four. What they have stated is it is the piece.
No, we have said all fees and
responsible.
we have said all fees and contentions are left open. That's it. Next case, please.
Petition of 2014.
One of the learned ASGs.
This has become infructuous, my lords. Matter can go before the Delhi High Court, so for the purpose of
You
consideration.
are drawing this then, or you are the ones who, the matter is going on before the Delhi High Court?
So your lordship, it has been adjourned signed now.
Well, this should
The
be.
order dated 8/1/2000.
So, but why do you want, let the Delhi High Court decide the matter?
We wanted to demand it back because since it has been delinked on 25th of.
So you withdraw this transfer petition?
We want, yes.
Sorry, transfer petitioner seeks permission to withdraw the transfer petition.
With the
In view of the statement made, transfer petition is dismissed as well.
Grateful, my lord.
Grateful.
There are two matters of similar. Of similar nature.
But the arbitration clause is no doubt there, but did not approve the designated officer. Instead, moved the application before the High Court.
What difference does it make?
But he should have approached the designated officer for arbitration.
No.
Paragraph 11.
No, there's another matter also in which the same type of clause is there, similar clauses there. We'll take it up together. You have judgments with you? You have judgments with you?
Yes, judgment.
Yes. Which judgment?
We'll take it up together.
Some other date. Lombardi judgment. Your matter again.
Good 29.
Got some other date, madam.
Let it be over. Let it be over. There's nothing much. I thought its moral is covered now.
4 rounds of litigation on their own side.
Next, 36.
Minutes may refer to the last order of 3rd December 2024. That's the notice for.
They have already filed the affidavit and they are saying the land is required for the development of the.
Plus, I have not been served with a copy of the affidavit, Millet.
Yes.
By the respondent's statement. No, I have not received it.
You require the land for that area, you already notifications or dispute.
We have filed the affidavit.
No, is the land required for the purpose of?
That's right.
Unless the affidavit.
Affidavits filed by the respondents will be served on the counsel for the petitioner. List for disposal and final hearing in the category of after notice miscellaneous matters on in the week commencing 21st of July 2025. There is no stay. There is no not done.
Just one humble
just get the data
My lords.
that and also check up whether groundwater
Yes,
is being used for agriculture there.
I appear for the groundwater authority, central government.
Just check up on that, whether they are using groundwater for agriculture.
My lords, apart from 1 or 2 states, every state in India is using.
We want this area itself, where they're claiming that the groundwater has gone down, so therefore further development should stop.
Please, ma'am.
The agriculture is also dependent upon groundwater.
And more so, my lords, agriculture.
They will be using higher percentage.
Yes, ma'am.
And in fact, my lord, when there is a
let's
development,
just
but as per the policy building.
Now, basically, it's
the
groundwater recharge or
Yes,
groundwater
rainwater harvesting
depletion
system is required.
is not the main reason. The main reason to retain land.
But that's just one submission.
That's the reason, because land values have gone up because there's all around development.
Lord, in fact,
Yes, sir, just Minola,
reply
not
filed
concerned.
for the High
But
Court,
as
they
this-
have pointed out there are serious doubts about the bona fides of the petitioners, my lord.
So there must be.
Yes.
It must be, because he's not going to use it for agriculture. He's certainly going to.
The petition was filed besides his petition number 1 on behalf of Gram Panchayat by so-called sarpanches. There are no resolution of the Gram Panchayat. The respondent number 1 also no office found. There is no office. It is not a registered society.
Just give him a copy.
Yes, I just want
Response to the said affidavits may be filed within 4 weeks, within 3 weeks.
There's just one small submission, Milas. Let's respond number 4 directed to file the counter. No counter is.
Doesn't make a difference. If whoever is filed, we'll take that into account.
And there's just one submission, Milas. The respond number 5, the counter that has been filed by the groundwater board. They rely on a particular 2024 report. That report has not been placed by them.
Public domain, my lords.
It's available on internet.
Yes, ma'am.
I'll just check once.
Grateful.
Thanks,
Clear.
My lords, in this matter, I'm led by learned Solicitor General, my lord, and seeking a very short adjournment in the matter.
It's also, my lord,
The week commencing. Bench presided over by Honorable Mr. Justice Deepak Datta. When the week commencing 13th of May 2025.
If my lords may kindly recall, in the last order, your lordship had noted the judgments and possibly your lordship had indicated about
I know, but time is too short.
lordship please assign this. Get
Is in the first matter when lordship issued notice, no reply has come. The
We have to fight with
Some more time is needed,
None of
2
the
weeks time.
matters.
Okay.
Because-
The request was for the.
Yeah, my lords.
Yes, please.
I am an intervener in this petition.
I've seen that application. We'll see.
Lords, my difficulty.
No, please.
Lords, there is a
speak up.
difficulty, otherwise I would not bother.
No, there is no difficulty.
Lord, the difficulty is across the country. This petition is being used as a plea to not let the High Court adjudicate the matter on its own merits. That is the difficulty I am having.
They
Otherwise, I
have
would not.
remanded it to the, we asked you to go to the High Court, they'll deal with it.
Lords,
Right,
that will be sufficient.
At the request of the senior advocate appearing for the election commission, based on is granted 3 weeks time to file the price to counter affidavit. We rest in the week commencing.
In fact, Lord,
21st of July 2025, the joint if any, within 3 weeks after service of the replies to counter affidavit.
Lords, can I just show my lord what's happening on the.
This you press it in the High Court.
Because they are not allowing. The reason is that because it's pending. The pendency of this, if your lordship just listen.
Will clarify the pendency of the present petition.
Otherwise,
not have any bearing on the writ petitions, if any, pending in the.
Your lordship, I am appearing for the unions. We will
So
also be
deeply-
filing over counter, your lordship. Here,
Not required this for them. You don't have to file counter.
The union has to file the first matter because that's the amendment, will not be the union.
Okay.
Other-
Union of India will also file the counter affidavit within 3 weeks. The joint if any, within 3 weeks after service of the counter.
Can I request for my intervention be allowed?
Wait, or application.
I will.
Not,
Now that
not
my lord,
required, not required, but we are not dismissing it.
that liberty will suffice for me. Keep your.
There's also 29.1.
Your Lordship may fix the matter of final
Because
disposal, Your Lordships.
Just 1 minute.
Milords, grant me 4 weeks to file, Milords.
Just 1 minute. This is the matter. We want to dispose of these matters. These are simple matters. There's nothing left in all these matters.
Lordships can take it up next week
No, we are finishing it off. Why should we adjourn it?
Because Wakalatnama has been issued late in the evening yesterday.
Please file it. We'll take it on record.
The arguing counsel is unwell today. That is why, Milords. Allow me to file Wakalatnama and Milords.
There's nothing in this.
Milords can
You can't erase the arbitration clause.
That's exactly our point.
You can't erase the arbitration clause.
Your Lordship may have it next week.
And that's abuse of power. That's abuse of your authority and power.
Obliterated the whole thing.
Allow me to
And
file.
because in our case,
I think-
arbitration went on for 3 years.
That's like saying.
And it went on with their own consent earlier.
As per office report, service is also incomplete. Lordship may allow me to file my Wakalatnama and response.
Service, I believe, is complete. It's just that they haven't entered appearance.
In relation to respondent number 1, it is
In which matter?
in first matter.
29, I'm seeking for the password. The first matter. 25, I was seeking a password.
May I request your Lordship to take it up next week, Your Lordship.
In the judgment, it says, judgment by the constitutional bench judgment. This issue is specifically addressed.
No, Milords.
No, it has.
No, Milords. In fact, we
Because,
are also relying on the same constitution bench judgment.
You should, but then accept the consequence also.
Lordship, then
Consequence.
fact-
We can't erase the arbitration clause.
And Milords, I don't think that was the
And
intention.
there is, if I'm not mistaken, an item number, just give us that item. Yes, but Lord.
25.
25, there is a reference to an earlier judgment of this court wherein such an arbitration, the arbitration clause was upheld.
please, Milords, Kashish developers, Your Lordship.
No. Kashish is on a completely
No,
different point.
arbitration judgment, the clause
Kashish
is
is a
upheld.
judgment where the SLP is dismissed.
In Indian Oil Corporation Limited and others versus Raja Transport.
That's Justice Ravindran's judgment in Raja Transport. But that's right. But Milords, and that's
That
on a
was against this view.
correct. But that's a slightly, and I'll Milords be able to explain that judgment away. That's not a problem at all, Milords. That is not going to come in the way because
All these matters you said, realist before a bench presided over by. This Badiwala in the week commencing 19th of May 2025.
Because that's likely to be the miscellaneous week. That's the only consideration, Milords.
13th of May 2020.
Lordship pleases. Lordship, please.
Replay, please.
I thought it will be probably shifted because just the first day it's normally not taken up. They would have given a date of choice before I made it in the last week. If I'd given it in July, it would have pushed around more. It won't be taken up on 9th in the week commencing 19th. Some date would be given by the Honorable Judge.
I know, but the only thing.
Okay, we make it 30.
Lordships may have done that. I'm so deeply grateful.
Well, I'm appearing for the Union Territory. Yes, I'm seeking some time to file the compliance minutes.
In the week commencing 11th of August 2025.
I'm so grateful. You're blessed.
11th of August 2025.
What I'm submitting is, should the compliance come even by now? Maybe we may not insist, my lords, on this. But
What compliance they want?
Lord,
They want to be regularized. So that's a contentious issue.
no. The judgment is attained finality in the sound of litigation by the Honorable Red Court Bates of 2016, upheld by the Honorable Division Bench, and SLP.
We'll say.
Dismissed by the
Next case.
I'm so grateful.
Post.
Please, Lord. The High Court. Well, the High Court had protected me for 2 years. I have cooperated. The reason for giving me protection.
You have taken 39 lakhs.
Well, that's what I'll try to explain. If your Lordship sees what happens with this. Well, I was working in this pet shop.
Lady protection doesn't mean anything.
No.
Because these people they underwent surgery and you took full advantage of it.
Nothing of that sort happened, my lord. I have maintained a diary. I have kept, please consider.
Money came to your account. You paid 65 lakhs.
I have paid 65 lakhs.
Paid 39.
No, even it was not now. It was that time, that period. You know, I have been paying regularly. Just consider this. I have got a diary.
Please.
I have got a diary. I have maintained.
Sorry.
You know, consider this.
Sorry, they become bankrupt. They took the loan.
That's not right. What they are saying is not right.
Sorry.
Apparently, I have, if your Lordship sees the additional document which I have filed, I have kept the entire diary. I have paid.
How did the money come to, so much money come to your account?
No, that's what I'm saying. There is a loan borrowed from the bank that they have said that
we are not inclined to interfere with the impugned judgment and especially petitions.
Whereas.
In 32, well, it's because of the Good Friday and the holidays. On Wednesday, because I'll have this. Wednesday, only this. I just don't want to miss it. We tried, person has flown, but it actually flown. Wednesday is 2 days after the holidays open. But she will allow that. I'm only asking for
Lordships have kept it. I mean, it's only to find out if they are putting.
Well, that I will put your Lordships on Wednesday. Either way, your Lordship will either have or not have it.
In order to enable the appellant to inform the court whether these 300 crores would be paid on or before.
So Lordship will not say on or before. Let me come back with the offer on Wednesday. Then your
Will be paid.
No, I will tell you the offer on the day.
Can be paid relist in the week commencing 28th of April 2025.
But if you are it can even before.
On that day, so could it be on?
Let him come.
Very well.
No, fair enough. But could it be on the 28th?
I normally give it in the week commencing.
All right, very well.
But one thing. Yeah, no, very.
My lords, this is a very unfortunate case wherein, my lords, my application for recalling was dismissed, my lords.
What can be done? Twice it's been dismissed.
Yes, my lords.
And you are working. You are also working.
My lords, but it's about 130 kilometers. Impossible for
No,
us to
sorry.
travel.
Sorry, please. You are capable of doing it.
My lords, we have checked.
No, please.
Still, the matter was filed. Recalling
Doesn't-
application is filed, my lord.
No, you can't repeatedly do this. We are not inclined to interfere with the appeal judgment and especially petitioners. Yes, please.
My lord, I beg to appear for the petitioner.
Yes.
My lord, the petitioner Jamaat has. May I, my lord?
Yes.
Well, the petitioner Jamaat for the last 58 years has been administering the Wakf property at the instance of the Wakf board. Well, after 58 years, a person claiming to be a legal heir of the Wakf files an application to be appointed as a mutawalli of the Wakf. My lord, this is against the canons of Mohammedan law. My lord, I take my lordship. And it is in the teeth of the decision of this court, my lord.
Not send the right signal.
Removal was on account of wrongdoings. The earlier removal was on account of wrongdoings.
Yes, my lord.
So now those wrongdoings are not there as far as the new one is concerned. But before that, it was normally hereditary.
My lord, in fact, my lord, I would rely upon the dictum of this court.
Oh, that's true.
My lord, there is no right. My lord, there is no right. My lord, I take my lordship to page 18, the internal page 18 at paragraph 43. There is no hereditary right to be appointed as a mutawalli. The only exception is, my lord, I have to plead custom.
That's what here.
Custom here.
But I thought here what has been pointed out is that in this case, normally the hereditary, it was hereditary. There was some misdoing by one person. There was misdoing by one person.
Yes, my lord.
And therefore the board had to step in.
Yes, my lord.
So now that the person has died and the other person has now come forward, then the High Court felt it should go back to the original.
My lord, my lord, here it is not the case that the petitioner died. My lord,
earlier Mutwalli has died.
No, my lord. The Wakf died. Subsequently, her daughter
was
the mutawalli.
And she has died. She has also died.
No, she was removed.
She was removed. After removal, she has died now.
My lord, that is not the position here.
So she's not the one who's wanting to become the Mutwalli.
No, my lord, no.
If somebody else.
The person.
Yes.
Before 58 years.
Okay, show us what is the law.
My lord, at paragraph 43, my lord. Internal page 18. Thus, we may conclude that while no person can claim the office of mutawalli by virtue of being a heir of the Wakf or the original mutawalli, if they can show through a long established usage or custom of the founder intended the office.
But in this case, when was the Wakf formed?
My lord, 1949, my lord. Wakf Nama is 1948.
48. And till when was the Mutwalli from the family?
My lord?
Till when were the Mutwallis appointed from the family itself?
My lord, 1966.
48 onwards, the Mutwallis have been from the family.
Only one Mutawalli, my lord.
One Mutwalli.
That is the daughter.
And when was she removed?
My lord, in 21/11/1966. She was removed because they wanted to alienate the property.
Okay. Right up. Returnable in a week commencing. The 18th of August 2025. Notice to be served by all votes, including custody. The trust for the petitioner has relied upon the judgment of his court in 2019-16 SCC 1 to submit that the impugned judgment is unsustainable.
Yes, stay there. I may pray for a stay also, my lord.
No,
my lord. The only difficulty is, my lord.
We'll see.
My lord, he should not take over the.
No, we'll see.
He shouldn't be appointed as a mutawalli.
Next case, please.
My lord, only for the interim basis.
They're both in the special petition and the application stage. Next case.
May I please, Your Lordship? Lord, there's a fresh application on behalf of the Board of Secondary Education only on the limited issue of untainted people. My Lord, since 2000.
Are you holding the exam?
Yes, my Lord, the state government has already written to the state commission to initiate, my Lord. I
am appearing for the state, Lord.
State fellows, we have initiated.
I am for the board, my Lord.
1 minute, please. Mr. Devedi, when are you holding the exam?
Lord, we will complete the whole examination within 3 to 4 months.
The SSC has to hold the exam.
Not beyond 4 months.
The process. It takes a little time, Lord.
When will you
Because,
start?
Lord, first of all,
when will you start advertisement?
We'll start the process in 1 week's time, Lord.
We start by the rules
By
framed
December,
by the
Malad,
government.
it should be done. We'll do it by December, Malad. Preparing for the state, we shall finish it by December. We shall complete the everything by December.
Our difficulty is
When
in
will you hold
2016, there's no
We
recruitment.
have,
when will you take out the advertisement?
Yes.
Give us the
Milord,
date, outer date.
by May, my lord, we'll take it out because, my lord,
I
rules are
means
rules are
I
formulated
mean
before
that
that.
advertisement will be published in April.
May.
Because, my lord, first step is the state formulates rules.
What rules are already formulated?
No, Manoj, we have to
Fresh rules
end
are
of April, they'll be formulated by end of April.
Rules are there.
The next step is the advertisement, and my lord, there will be 4 advertisements, 4 different categories.
Okay.
And then, my lord, will be the exams, and then
We will only grant extension to the teachers,
yes,
not to the class 4, class C and D. Sorry.
right.
Because there is vast case bungling in that, which is quite apparent. Class C and D will
My
not
lord,
be there.
schools
What will-
require the non-teaching
Maybe
staff as
non-teaching staff, the schools will have to deal with it. Sorry.
I know that's your lordship's prerogative. The only thing your
There are
lordship must keep in
6,000
mind is,
there's
since
6,000.
2016, there has been no recruitment because of this litigation pending. So we are actually understaffed today in any case.
We are concerned about the students and therefore we permit them to
Yeah.
join in. But then you'll have to give an undertaking that the advertisement.
By December, everything will be over.
By then advertisement will be out by 31st of May 2020.
We'll do that, Lord. We'll do that.
And in case it is not out,
no, my lord, advertisement will be out by 31st.
We shall do it, Manoj.
It will be done. It will be done.
We'll do that, Lord. We'll do that.
and the process will be completed by
December, Manoj, everything.
31st of December.
Correct, that's all I want.
Lord, your lordship,
I'm grateful.
the petitions will be heard, my lord. Try, my lord, to segregate. My lord. Para 28 says, my lord, that the segregation is impossible. Today, my lord, only 2 submissions. Today, my lord, we don't know, my lord, who are tainted and who are not tainted.
My lord,
So, 1 second.
my learned friends have been, my lord,
For the
making an incorrect statement.
But let him argue.
My heart,
If we agree with it, we'll put it to you. Why do you not?
our heart bleeds for the children, my lord, but it is their responsibility. Today, all of them are, we are here, my
What
lord.
do we do?
Submit.
So we do. What do we do?
Submit. We are, all of us are
What
here,
do
my lord.
What do we do? We
No,
do
no,
not-
correct.
Milord,
The suggestion is, my lord.
I have one.
So this is a classic way, my lord, to circumvent, my lord, the order of this honorable court.
It is only for a
B
period
part
of
is, my lord.
4 months.
Milord, why don't the retired teachers be appointed for this time period?
My lord,
But
we
I
are
put
here
a
because
question,
of the
my lord.
board, my lord.
Myself, why the retired teacher? Because there are provisions in law.
Today.
There are provisions in law.
I would suggest,
And my lord, even my lord, High Court, Supreme Court, retired judges.
My lord, there are, my lord, retired teachers,
Administrative
my lord.
exigency, my
They are
lord.
not going to.
They are not under any cloud of doubt.
Right.
These people are under
MA
cloud, my lord.
number 1709 of 2025.
That's right.
We are inclined to accept
And
not
yet least
made in the present application. Insofar as it relates to the assistant teachers for classes 9 and 10,
11 and 12.
classes 11 and 12.
9 to 12.
9 to 12. Oh, these are 2 separate
Very
classes.
well. 9
9,
and 10.
10 is one category,
11 and 12 is another category.
Yes. Separate rules.
Subject to the following conditions. 1. Advertisement for fresh recruitment shall be published on or before 31st of May 2025. 2. Examinations and the entire recruitment process will be completed by 31st of December 2025. Full stop. The state government, the board, and
Commission.
the commission
Secondary.
shall file an affidavit on or before 31st of May 2025, enclosing therewith a copy of the advertisement as well as the schedule, so as to ensure the completion of the recruitment process by 31st of December 2025. To stop. In case advertisement is not published by 31st of May 2025 and the affidavit is not filed by 31st of May 2025, the appropriate orders will be passed by the court, including imposing costs and publication of the present order.
Only one.
Next paper. We are not inclined to accept the prayer in the present application insofar as where I said untainted. We are not inclined to accept the prayer in the present application as far as Group C and Group D. Group C and Group D employees are concerned, as we feel. They said as the number of tainted category candidates in the said established tainted category candidates in the said classes are substantively high in number. First of secondly, what has prompted us to pass an order in respect of untainted assistant teachers is that the students should not suffer. Students undergoing studies should not suffer on account of the order passed on account of absence.
So far as
which has resulted in the order passed by this.
Milord, the language used in your lordship's judgment is appointees not found to be tainted.
Not specifically found to be tainted.
Not specifically.
Not yet found to be tainted.
Not specifically paragraph 46.
Specifically found to
I'm deeply
And
one more thing, my lord, the tainted candidate, my lord, should not go to school. My lord, that may be recorded.
Mind this expression.
My lord, the tainted candidate should not go to the school. My lord, that may be recorded.
Two things, my lord.
Just one.
Till date, my lord,
My lord, kindly be recorded that the tainted candidate.
my lord,
But I humbly submit, my lord, that tainted candidate should not go to identify tainted candidates.
in your case, you know your result.
my lord,
No, I'm only saying.
My lord, may I just humbly
add one?
The identified tainted candidates, my lord, should not go to the school.
Grateful, very grateful.
Identified tainted candidates, my lord, that will create, my lord, something difficulty for the children.
Milord, only one thing.
They are the economically the poorest of
No right in accrues will not in favor of anybody. No right accrues. Otherwise,
This order will not be read as conferring any special rights
on those who are ad hoc.
or advantage on the aforesaid teachers insofar as the fresh recruitment process is concerned. Next case.
One thing, my lord, the OMR sheet not yet uploaded because the High Court order, my lord, there is a specific direction, my lord, for publishing the OMR sheet, my lord, for public viewing. Otherwise, my lord, it will not be identified who are tainted and who are untainted.
This is
My lord, that ought to be
already
published. Otherwise, my lord, the whole thing will be.
The identified tainted candidates, my lord, may not enter the school.
Tainted will be a very broad brush stroke and there'll be many will be put under the bus because of this.
Milord, the list has already
Who are not.
Milord, it has been prepared. Let me assure your lordship, Milord, the list of persons have been prepared.
Once the matter is over, please do not argue.
But at least not yet
Give the
published.
appearance,
That's
because our names have not got reflected in the portal.
Going to the school.
Next.
Who are going to the school there.
But may give the appearance in 35, our names have not got.
Okay, fine.
Okay. Good.
Let's
Grateful.
I'll just, let's I beg to appear for the appellate.
Yes, please.
Let's,
No, it's like this. 1 minute, please. It's like this. As far as the Electricity Act is concerned, there is truing up done from time to time. When truing up is done from time to time, the past amounts are to be paid by the current consumers. You can't collect it from the earlier consumers or bill it in the earlier bills. For the simple reason, it will be impossible. So the truing up, I didn't particularly like the language in the reasoning given, but it could have been answered in a very simple way. When past areas have to be trued up and burden has to be passed on the existing consumer, you being the existing consumer will have to pay.
So in this
case, Mishra has no application.
No, so two or three aspects. So in
And
this
it need
case,
not be reasoned in such a long way.
no, can I just tell you on facts? In this case, the amount as far as the SFS is concerned was in fact crystallized on the on 1st of September 2022 by the RERC order. And the notice of demand, my lords, was sent to me. Your lordships will have that at document A4 and A5, where the notice of demand was sent to me. Now that is prior to even the commencement of my PPIRP. That's one.
Maybe.
No,
but the issue is here because the billing will start much later.
No, the question is not a billing, and I'll tell you, lordship.
Because what happens is the orders are passed, the orders are challenged, there is an appeal provision. Billing starts much later.
No, so
but really, it's not areas. It's not the areas which are being collected from you. It's the present dues which is a result of the truing up, which includes the areas.
So there were two aspects. No, so here there were. Can I just clarify two aspects, my lords, on facts? My lords, here there were two facets of billings. One, my lords, is the SFF.
Such long reasoning should not have been given. In fact, it looks as if it's contrary to our judgment as far as electricity companies is concerned. Need not have been gone into. All that is required to be said is these are current dues payable because of the orders passed, and these cannot be treated as areas prior to the CIRP process.
So, my lords, I'll tell you, lordships, why on facts, my lords, I may have to clarify two aspects. Because there were two components which came in. One is the fuel surcharge, where your lordships, my lords, has a view which is that the truing up happens later. Under the regulations, it's supposed to happen within 3 months, my lords, of a particular bill which is generated, which in our case, my lords, because it related to 2021 and 2022, should have been deen within 3 months, which is prior to my.
Doesn't make a difference. Even if it is done later, you'll have to pay.
Can I just explain? Second, my lords, was the SFS bill, which is the special fuel surcharge, which arose because, my lords, there's a judgment of your lordship's court in an Adani Power matter, which has had a cascading effect where, my lords, a large recovery has to be done. That pertains to the period 2013 onwards, where in fact that truing up was done by the RERC, and that order was passed, my lords, on the 1st of September 2022, and they issued to me a demand notice, which is at document A5 on 20th of September 2022. So in our view, both of these were crystallized. Now what happened, my lords, I'll tell you, lordships. Because the scheme under Chapter 3A is slightly different from a regular CIRP scheme, what I am supposed to do, because when I'm an MSME, when I go and file this, is an entirely different scheme under section.
MSME, so therefore the management has not changed?
In this case, my lords,
no, the management has not changed?
No, in this case, it has not changed. So I'll tell you, lordships, what we did. So when I filed, my lords, under Chapter 3A, I, in fact, am supposed to file a Form P10 under Regulation 20, which is specific only, my lords, for these PP, they're called pre-packaged IRPs. In that form, I set out their dues at a sum of 2.99 crores. And let me tell my lords that that entire 2.99 crores, which is the claim I had set out for them, has been paid to them because...
That's fine, but this is not claimed included in 299 crores.
Now that is, my lords, the point. The point is this...
Because this will be a claim post that date.
It's not. That's exactly my point.
It will be for the simple reason that maybe the judgment of this court on the question of SLC may have been pronounced earlier.
No, they raised their demand. If I could have well understood if they hadn't raised the demand. Please have a look at A5, page 168. In fact, in my respectful submission, this matter does require consideration.
Let's see if that's so. We'll see. Otherwise, there's no.
Let's come to
the reasoning is little.
Look, I'll come to the law.
Because it's trying to rewrite the law.
Can I just make one respectful submission to subject to your lordship's pleasure? Look, this is in fact one of the first few cases under Chapter 3, which have in fact come to your lordship's court. In fact, I believe there was only one other decision which has resulted in a case from Bombay, which is also not there before my lords.
Yes, please.
Yes, my lords, if your lordship sees page
when will the CIRP process commence?
Yes, my lords, the CIRP process commences in 2023. My Form 10 is filed on 27th of April 2023, P10.
This is the first form?
This is the form.
This is not the proceedings. Proceedings, were they filed under Section 7 or 9?
No, they're not. So what happens is this.
This motto.
1954C. It's a completely different process. 54C, and I'll take your lordship's notes to the act, begins on 19th of April 2023.
Yes.
And my lords, in that, I am supposed to file a Form P10. I have to put that in, which I have filed on 27th of April 2023.
Yes.
In that form, your lordships will have that form. It's at page 286. At page 306 of your lordship's paper book, I have in fact set out their dues at 2.99 crores.
Including this due?
Now,
did you include this due in that?
What is set out in bracket is fuel surcharge. Now, if they want to have,
what was the amount claimed over here?
Because they have two claims. One is 2.4 crores and one is 2.1 crores.
So that obviously is not included in that.
So it's not set out here. Now, what happens is that the RP then intimates to them, telling them that now we're intimating to you that this is the claim form that has come in. If you have any objections, which again, under the statute and under the regulations they can do, they are supposed to come in and file their claim. But they don't come and file any claim.
Doesn't make a difference. But obviously you not included the fuel surcharge.
Even if I didn't, for a moment, I didn't. Then it is for them to come in and say this is.
They will only come up. They will only object in case you had included that amount as to be waived off.
No, I think
or to be reduced, or to be pushed into in future. You had not done that, so why will they come?
I'll tell you, may I just?
Not at fault.
No, I'm not.
Wanting to put the blame on them.
Just 1 minute, please.
Why did you not include that?
I'll tell your lordships. Please have a look at the definition of claims under section 3, subsection 3.
No, please. You had to include that amount. They may not come because they are not asking for waiver of that amount.
But the point is this. When you are invited to look at the claims, what does section 3, subsection 6 say? Because this is going to have...
No, please. You have to come in.
No, I'm not...
You are the ones who wants the waiver. They are not the ones who are seeking the waiver.
I'm sorry.
They'll be deprived of their money.
No, I'm not in the waiver.
And therefore, we have to protect their interest.
No, I'm not in that. Please hear me out for a minute. When you have a resolution plan, now supposing they had said no, the claim of 2.99 crores is incorrect. It should in fact be 5.5 crores or whatever it is. I've obviously got certain funding that's come in. Some of the banks have taken a haircut. In fact, the financial creditors, in fact, have to approve this by 66% majority. So the banks look at a haircut. They look and seeing how much.
They will not participate in it because you not included that.
With that, I'm sorry, all I am requesting is this today. First of all, the point is that today, and there are your lordship's judgment that, in fact, and I'll place one in the regular CIRP, that if you have an obligation when a claim is put to you, and you decide not to come in and file a claim, then can you?
We are not, Mr. Governor, we are not.
But this is.
We're not impressed with that.
But
you had to quantify the amount. Why should they come?
No, but if I have wrongly quantified
please.
But the point is this. Can I just?
We have some reservation on the reasoning.
Can I cite one decision?
On the reasoning given by the National Company Law Appellate Tribunal, which can be interpreted as if to be not in agreement with the ratio in Phosphate Archer Vidyut Nigam Limited versus Raman Ispat Private Limited and others 2020 SEC 16. We are not inclined to issue notice, as we are of the opinion that the question of that the truing up insofar as what was the first cause? Fuel surcharge?
The first is fuel surcharge.
Fuel surcharge.
That's right.
Was subsequent to the commencement of this proceedings, before the adjudicatory commencement of the proceedings under section 53C of the Insolvency and Bankruptcy, 54C of the Insolvency and Bankruptcy Code 2016. So stop. The same would be also correct as far as.
It's factually, that may not.
But the same would be also applied as far as special fuel surcharge amount is concerned. Stop. Our learned senior advocate appearing for the appellant Sri Rajasthan Syntax Limited had relied upon a notice stroke order dated
20th September
20th September 2022, raising the said demand. However, during the course of hearing, it was accepted that in form number 10C, the amounts referred to in the notice to order dated 20th of September 2022 were not included. That being the position, we do not think the review order, review judgment requires interference by this court, and accordingly the appeal is dismissed.
Deeply grateful.
Your Lordships,
My Lord's, apologies. We had mentioned this matter yesterday and today morning also. The thing is, the client had very specific instructions that they wanted to brief a senior. So even though we are...
What is there? Yesterday we said that if you want, you could not issue notice. So let it, we say the notice will be issued without Vikalatnama, that's all.
My Lord, notice will be issued?
Without Vikalatnama, that's all. That is the issue.
No, my Lords. My Lords, what had happened was, my Lords, this is an SLP that comes against the dismissal of a 711.
Oh, okay, no, okay. That's the transfer petition. That's a separate matter. The 711 has been dismissed, so what can be done?
So, my Lords, the problem is this matter was in defects. My Lords, it had gotten listed yesterday as part of the Wakf matters, and that's why yesterday it was detagged.
Okay.
My Lords, because it was...
Right now.
So, my Lords, we adjourn it
Next. Counsel for the petitioner relist in the week commencing 28th of July 2025.
My Lords, that may be...
No urgency.
No, my Lords.
711 dismissed. Suit will proceed in its own
No, my Lords may just... My Lords...
Suit will proceed in its own case.
My Lords, the issue... My Lords will just see one thing. The fact, my Lords, here is that in the order...
Where does the suit get over in 3 months?
Because it is clearly barred by limitation. My Lords, there is a 60-day period which the High Court does not...
We'll examine on when it comes.
My Lords, if I can then show 2 pages. If my Lords, just 2 pages.
You're not arguing. You're wanting an adjournment. You can find us.
My Lords, my Lords, then give first week July, my Lords.
It's second week, third week of second week is right, correct? Because first week will be the miscellaneous week. Next case.
Lordship,
this is accurate.
There are about 21 petitions being asked for transfer, and almost everybody except a state of Jharkhand official respondents service is awaited. So Lordship may consider it withdrawing all the petitions because these petitions are here. And
what is the issue here?
That Freedom of Religion Act, my Lord, in different states, which is subject matter here, notice has been issued to the parties in 32. Counter affidavits have been asked for, and these petitions were pending in the High Court.
Lords, there's only one seeking transfer of. Some of them are private parties. This is a PIL petitioner who's come seeking transfer of petitions pending in the High Court, some which are by private, some themselves are PILs. So notice may also be issued to those private petitions.
It has gone. Notice has gone, my lord, except one person in the entire 21 petitions. Everybody's notice has been sent already.
The week commencing. Dealers in the week commencing 21st of July 2025. I'm a little doubtful whether this a transfer petition may have a lot of consequences because the language of the sections are different.
And, was in fact
because and handling them all in the Supreme Court with different enactments may be very difficult.
They are already sub judice here.
Maybe.
Notices have been issued.
Let it come up afterwards.
Your Lordship, may I say one thing? I am not saying anything, my Lord. Just Your Lordship may have.
That's all, please.
16th January 2023
we have understood,
orders.
We have understood.
This honorable court wanted it to be filed, and that it was.
I therefore restrain myself. Next case. Because there are different enactments.
The other
different
matters,
enactments. The language will be different. Different provisions will be challenged. And it's not a central enactment. It's a state enactment. Then should we call them over here?
All those legislations are subject matter. Page 36, I have given the entire summary.
I'm not saying anything wrong.
But those writ petitions are pending on 21st. Your Lordship, may I make one more request? That they should not insist for any wakalatnama. They should number the petition, my lord. That's the.
What number the petition?
My lord, there is some objection because
it is pointed out by the senior advocate appearing for the petitioner that the registry is insistent on the power of attorney stroke wakalatnama, which the petitioner is unable to provide for the reason that the petition has been filed, which the petitioner is unable to provide. To stop. In view of the statement made, the registry will not insist on the power of attorney.
They may number the petition.
And the petition, without insisting on the power of attorney, will number the petition.
Deeply obliged. The other 32 petitions are listed on 30th. So, Your Lordship may connect it with that.
30th of?
April, my lord. Yesterday it was listed as showing on.
No, let us come up with it. Let it come. Yes, please.
Lordship may connect it with that whenever that comes.
No, we will see. On 30th also we can adjourn it to that. Next case. Yes. Can you hear us, Mr. Gauri Shankar?
No, we can't hear you. Unmute yourself.
Can you hear us, Mr. Gauri Shankar? Say yes. Say yes by raising your hand. Can you hear us? Okay. We cannot hear you. We cannot hear you.
My side or this side?
There's problem. Unmute yourself. Mr. Gauri Shankar, what we had said in the morning, I don't know whether you heard us. We are not inclined to entertain the present petition. If you want to file it before the High Court, you may do so. And on merits, let me put it.
It's not in.
You want to go to the High Court, yes or no? Okay. The petitioner or bears in person seeks liberty to withdraw the present petition states that petitioner, if advised, if petitioner, if he desires, may approach the jurisdictional High Court by way of writ petition under Article 226 of the Constitution of India. In view of the statement made, the writ petition is dismissed as withdrawn, with liberty is paid for. We have clarified we have not made any comments either way on the merits of the petition and whether or not it should be, the issues raised should be examined you very much. Hello.
No, this is yours ना, I need one. हाँ ठीक है, उस पे कुछ रिविजन नहीं, ये तो फाइनल में हाँ
May please, Your Lordship. Lord, I want to say something, Lord, with all responsibility, respect, and at my command. Lord, Your Lordships are going to consider whether to stay a statutory provision, whether directly or indirectly, Lord, which is by itself.
39.6.
A rare, okay.
Just 2 minutes.
Yes, yes.
Has changed the system.
Lord, I'm very respectfully urging, my Lord, as a Solicitor General representing the Union of India. Yesterday, my Lord, I have been working on this, my Lord, to answer Your Lordship's questions. Lord, the questions are pertinent, my Lord, there is no doubt about it. But, Lord, the difficulty is, and my Lord, I'm putting it candidly before Your Lordships, my Lord, knowing Your Lordship's magnanimity. My Lord, these are not the issues, my Lord, which Your Lordships may consider staying directly or indirectly, my Lord, based upon some prima facie or tentative reading of some of the sections. My Lord, we will have to take Your Lordships through the history of legislation, 23 Act, which is 100 years back, followed by 35, followed by 54, followed by amendment in 84. There was a committee recommendation, followed by 95 and the amendment. And in the meanwhile, my Lord, we as a government and as a parliament, my Lord, we are answerable to people. We received lakhs and lakhs of representations which resulted into, my Lord, some of the provisions being made. For example, my Lord, villages and villages are taken as Wakf. Private properties of individuals are taken as Wakf, my Lord, and I have orders which says when they approach the High Court that these are disputed questions of facts. Lord, it is a considered piece of legislation. Lord, the request is this, Lord. My earnest request. Lord, the petition is filed before the presidential assent. Lord, immediately, my Lord, it is being taken up. Your Lordships may take up, Your Lordship must take up. I am requesting Your Lordship to examine. Allow me, my Lord, allow me. And to be fair,
I just wanted to clarify, as far as the petition is filed before the president.
No, I'm not on it.
Concerned, just ignore them.
Ignore, but I'm not, my Lord, saying, my Lord, but to be fair to them also, my Lord, to be fair to them. Because it is a question where Your Lordship needs assistance. Because it would affect, my Lord, either large number of innocent people's, their right to land, their right to property, and at the same time, my Lord, some, my Lord, contentions with the petitioners are raised. And to be fair to them, my Lord, they also did not get, my Lord, sufficient, my Lord, opportunity or satisfaction.
They are not deciding the matter.
My Lord, Your Lordships are taking a very serious and harsh step, my Lord, in staying partly, indirectly, or in whichever way, my Lord, one may call it, my Lord, some statutory provisions without complete assistance, my Lord. My Lord, my request is this. I am coming directly to my request. My Lord, allow me to place within a week, and I promise Your Lordships it would come before Your Lordships within a week. My Lord, my preliminary reply, my Lord, some material with documents to show, statutes to show how, my Lord, this came into picture. My Lord, this is not, my Lord, with respect, my Lord, a matter Your Lordship would also like to consider on prima facie reading.
It's like this. We had a particular situation, maybe there are infirmities in that situation, and I put it across very clearly, certain infirmities which were there. We also said there are certain positive things.
I understand, my Lord, I understand, I fully
It's
understand.
not that, and let me also very clearly put it, somebody did say there should be complete stay, we said nothing, cannot be any stay. At the same time, we don't want the situation to change. Because, we don't want the situation, whatever situation today is prevailing, should changed so drastically that it affects, it affects, look, please, there are provisions like the provisions which you have enacted that 5 years. We are not staying that. We are not staying that because that can be dealt with. That can be, we are not staying anything like that. All that we want to do is, normally you are right, absolutely. One of the thumb rules which the courts apply, we don't stay the legislation at the preliminary stage. At the same time, there's another thumb rule also that normally when the matter is pending consideration before the court, the situation as it is prevailing today should continue so as not to upset the rights of the party. So therefore, we suggested two options.
Yes.
We suggested two things. You had yesterday said with regard to registration.
I'm not on merits. Let me complete my request to your lordships. I'm not saying that your lordships may not take up or may not stay partly or fully. Even for the purpose of deciding what will be the fallout of your lordship's order, also your lordship will need some documents. I'm saying it with a sense of responsibility that if your lordships were to say something about the Wakf by usual, what will be the fallout of that? Please hear us, my lord.
No, we are hearing you.
Allow me to place material on record. 1 week, nothing would change, my lord. 1 week, nothing can change, my lord.
But then, stay off. As far as appointment of boards is concerned,
not make any appointments, my lord. I make a statement.
Appointment of boards and councils is concerned. 1, 2. Number 3 is with regard to Wakf in use, wherever the properties have been already declared as registered properties.
If it is declared, my lord, if it is registered, that's the distinction.
No. Registered in terms of section 36 of the 1995 Act. I'm not talking about registration now. I'm not talking about registration now.
Let me take instructions on the last part and I'm possibly able to, my lord, say yes to it. I don't want to change position.
Yes, that's all. We don't want the position to change.
Position, government does not want to overreach your lordship's jurisdiction.
No, there's no question of overreaching.
I know.
We never say, Parliament makes laws, executive decides and execute the laws, judiciary adjudicates. We go by that.
One line.
But Parliament is entitled to a
correct,
fair, reasonable. It's Parliament, not will of the people.
1 minute.
Will of the people.
1 minute, please.
10 days, 15 days, Parliament will not be given.
Okay, fine.
After 15 days.
Okay, fine. We'll do that. But in the meanwhile, no appointments to the board.
No heavens will fall.
Okay, fine.
No heavens will fall.
Okay, fine. No appointments to the board, no appointments to the council.
I make a statement.
And no changes as far as
registered works are concerned. If that's part of law. That's part of the law, my lord. And if there is any.
Let us say something about registration. My lord, what is being today said is that hereafter no work will be registered without registration of the document. It will not be registered.
Fine. Clarify that. So then
if any from 1923, 1954, and penalties were imposable even then. I can
not penalty, claim terms.
And
Mr. Ranjit Kumar, please.
So therefore,
Mr. Ranjit Kumar, this is not correct. Mr. Tushar Mehta is on his legs.
No,
I am only earnestly.
1 minute. We got no difficulty, Mr. Mehta.
Within a week, my reading of the provision.
1 minute, please.
My reading of the provision is within a week, nothing can happen even if government wants to. And if not somebody is aggrieved, somebody can always come.
Appointments are not happening.
1 minute.
Appointment is in my hands, my lord. I can tell your lordship.
Correct. That is
no.
State governments are also there. Your state governments may not be in your hands. The central government is to appoint a bench.
State government.
Please, Mr. Ranjit Kumar, please. You're not representing all the states. Are you representing all the states?
Representing some
states. Correct. So therefore, please, as far as council, can we?
But I can make a statement. If before your lordship hears, if any state which is not represented makes any state appointment, may be treated as void.
Okay, fine. And as far as
it can't be not
correct.
candid than this.
Correct. And as far as the works which have been already declared and registered as, declared under the Gazette or registered as works under section 36 of the.
Of course. That's not my assurance to your lordships.
My lord use the word or otherwise.
That's fine, please fine. We got no, look, we are not anxious. What we thought was.
And your lordships are not. Your lordships.
We also want
overreach, my lord, the pendency of the petition. That's your lordship's concern.
One additional thing, there's one small additional thing. There's an additional thing, 3C12 and proviso. Because they will treat it as not a work. It operates by law.
No, Dr. Singhvi, once we say that the works which have been already declared to be
declared and registered.
Declared or registered.
And
1 minute, please.
Catch here.
They declared or registered.
Or work by user.
1 minute, no. Work by users are also registered.
Registered.
No,
yes.
That's the problem. My lord used the word or otherwise yesterday. My lord, the Chief Justice used the word for otherwise. That's the correct word. Because work by user, registered, may not be registered.
Okay, please. I'm dictating the order.
It's my assurance to your lordships.
Kindly see or otherwise.
Assurance to your lordships.
Give me the indulgence of 1 minute, just 1 minute. Would my lord?
It will not be required. I let you dictate the order. After that, it may not be sent.
Before dictating the order, please give us some time.
One sentence from the Ram
We are entitled to be heard, my lord. With great respect, I am saying.
Please just one.
With great
During the
respect.
course of hearing, 1 minute,
Please give 2 minutes, my lord. 2 minutes, my lord. I'm not. My lord, I beg to appear for the state of Chhattisgarh, my lord. And your lordships will find it, my lord, quite significant to know that the work board, my lord, of the Chhattisgarh State Board is supporting the legislation.
Right?
Now, my lord, please,
I'm sure there will be Muslim organizations supporting the.
The tenure of the.
I'm sure there are Hindus who are opposing this.
My lord, the Learned Advocate General.
Not a religious issue.
Please hear me, my lord. The Learned Advocate General is here. He's saying that the term of the board is up to 2027.
Please, that's all, Mr. Srivastava, not required. Right.
Please hear us, my lord, at least.
Nobody will interrupt now.
Only one line. While dictating the order, my lord, please consider, except my lord, the appointment part, the fallout of your lordship's
No, nothing. No, there will be no
cannot
fallout.
contemplate.
No. We are not. We know that. Right now.
There is only one, my lord.
Please. Nothing. Nothing at this stage. Right now. During the course of hearing, Mr. Tushar Mehta, Learned Solicitor General, states that the respondents would like to put in a response, which will be short response to reply, which will be filed within 7 days. He further states, till the next date of hearing, he assures the court that no appointments will be made to the council and the board under section 9 and 14 of the amended provisions to stop. It is also stated that till the next date of hearing, the works, including works by use, already registered or gazetted.
Yes, sir.
1 minute, please.
Yes.
Just let me conclude.
I'm sorry. Your lordship, sir.
What's
gazetted?
Let me concentrate in
My apologies.
including work by use, whether declared by way of notification or by way of registration, shall be notified, neither will the character be changed. Full stop. Next paragraph. We take the statement on record. Full stop. Let the reply, counter affidavit on behalf of the respondents be filed within 7 days. Response thereto may be filed within 5 days thereafter. Service within 5 days of the service thereof. Full stop. List in the week commencing. Yeah, you only 5th of May. Okay, 2025 at 2 p.m.
Intervention.
May I have a word? There are states intervention.
One more thing now. Just one. You want to-
State government.
Yeah, for the work.
Intervention by states.
What
The state governments are here.
No, this is not being treated. Yes. States and
One minute, please. I'm coming to the logistical issue. Just one. As far as the writ petitioners are concerned, I want only 5 writ petitioners to remain in court. We cannot have so
That's
many.
fine, we'll organize that.
It will be impossible for us.
We'll
also-
organize that.
It's impossible for us also to read 110 or 125.
The object.
That's not it. We'll organize amongst ourselves.
Just one.
Same point.
We only want 5. We would have preferred fun, but possibly this may not be possible. You select the 5. Others will be treated as disposed of or will be treated as. Just 1 minute, please. Can we have some decorum in the court? We only want 5. Whichever one you select, please select and inform them within 1 day. Maybe by Saturday, you inform them that these are the 5 which will. Other writ petitions will be treated as either applications, or should be treated as disposed of wherever you. And we are not going to now mention the name of the parties. They will be all referred to. The petition will be referred to
Wakf
as
Amendment Bill.
in the Wakf Amendment Bill. Wakf Amendment Act.
Kamala, may I have?
If there is a writ petition challenging the.
2 minutes. Let him say 2 minutes.
Nobody will say anything.
2 minutes each.
Without, nobody will say anything. This is not a place where you can.
One submission, my lord.
Not only one submission.
1 minute, please. That's it. I don't want any more discussion. One, and number 2, please appoint a noble counsels amongst yourself to whom all the papers can be given and who will be filing the rejoinder.
Well, as your lordships have said,
But there is
but
an
by
intervention
user,
by the
declared
state
or registered.
May be allowed.
Either declared or registered.
Intervention.
Both.
I just.
Declared or registered, including work by use.
Exactly.
Oh, including, that's fine.
Including work by use.
That's fine then. Can you make that clear?
I know what I'm declaring.
That's perfect. That's perfect.
Lordships, item
One more
57.
sentence, fellows, one more sentence. That 3C, 1, 2 and proviso is self-executory when the law came into force.
No.
When the law came into force.
We have
That's all.
Intervention.
Lordship, state government, lords have them presenting the state government. I'm
1
representing.
minute, please.
Intervention.
May I suggest?
Intervention.
1 minute, Mr. Chair. I remember that.
States.
I don't remember. It's not so bad.
I'm requesting for the state
1
government.
minute, please. Now 1 minute, please. Similarly, on your side, please appoint a noble
You, me
counsel.
and including.
Correct?
Including,
And
yes.
on your side, please give us the list of councils who
We'll do
will be arguing.
Yes.
We'll do.
And the list of councils who will be arguing.
Well,
We can't allow
I
everybody
agree,
to argue.
well, we'll do that.
We cannot allow everybody to argue.
Interventions may formally be allowed. Item 57, my lord, is a substantive writ.
Instead of disposing the
State governments have a stake in the matter. They should have been.
We'll let the petition remain.
Five council will argue only. That's much
That
better.
my learned friend is right. 5
Lordships, item 57.
Right now, it is agreed by the council for the petitioners that they will identify 5 writ petitions which will be treated as lead cases. So other writ petitions will be treated as applications filed in those writ petitions.
Lordships, item 57 is a substantive writ, my lords.
1 minute, please.
Let the writ petitions remain, which is 5 council remain.
That province.
Now, the point is, it may not be in the main petition, but there are non-Muslims who have been excluded.
Only 5 council will argue, brothers.
Mr. Dhawan, I'll tell you the reason. No, Mr. Dhawan, I'll tell you the reason. The difficulty is with this large number of petitions and continuous flow of petitions even today. I've marked some case matters for 28 today also.
Well, it doesn't matter. We'll argue that question of law in any case.
We can argue the question of law.
My lord, now,
Lordship, the substantive challenge to the 95 Act is there in item 57, my lords, on threshold of secularism.
1 minute, please.
Sharia is being applied to the state lands, my lords, in
We are aware of that.
those may be kept upside, my lords.
those will come from both sides so that it is being organized.
Right on. The writ petition challenging the amendments made, the earlier amendments
The 95 Act.
The 95 Act.
The 95 Act substantive.
95 Act and 2013 Act. Both are under challenge or only
95 substantive under with the amendment.
the writ petitions challenging
Item 57.
95 is a substantive act. And
95 Act
Let the Chief Justice
Can I
dictate.
dictate, please? Can I dictate? The writ petitions challenging the WAF Act, the WAF Act 1995 and the amendments made in 2013 shall be separately shown.
I'm grateful.
What's this? So stop. It will be open to now, Mr. Mehta, which way will you file the reply?
Your Lordship may fix the date, I will not seek extension.
No, will you file the reply to that?
I will not wait for them to select 5. I will keep the title blank.
Okay.
My affidavit will be
Okay,
ready.
it will be separately shown in the cause list. Liberty is granted to the petitioners. As a special case, liberty is granted to the petitioners who have filed writ petitions challenging to 2025 amendment to file response to the said writ petitions. Stop. The Union of India may also file, Union of India and other response. State governments may also file reply to these writ petitions.
And Wakf boards.
And the Wakf board may file reply to these writ petitions within period of 7, briefly reply to these writ petitions within period of 7 days. To stop. Rejoinder if any, 5 days thereafter after service of the replies through counter affidavit.
Lordship.
To stop. Next page. Next. The both the sides, that is the petitioners and the respondents, will appoint nodal counsel, whose service will be effective. The details of the nodal counsel will be
Mr.
furnished.
From our side.
Kanu Agarwal on our side.
Just give it. The details of
We'll give it to them.
Okay. Both the petitioners and the respondents have appointed nodal counsels for effective service and for filing of pleadings. The name and details are as under. Right now. You also gave your nodal counsel.
Yes, Mr. Vishnu Jain, my lord.
My lord, as far as the replies by Wakf boards is concerned, there are so many Wakf boards.
The Indian government. Let them, if somebody wants to work, let them work.
We may be at odds with the Union.
He talks about the scheduled tribes protection. But I am representing those scheduled tribes, Lord, who have been protected.
You may file a reply.
So, Lord,
I said, no, not required. We clarify that the hearing fixed on the next day will be only a preliminary. It will be a hearing will be a preliminary hearing for directions and if required an interim order.
Obliged. Deeply obliged.
Deeply
obliged.
On the lighter side, the Lordships have changed the name in Ray so and so. Now new petitions will stop.
Very deeply obliged.
The cause title in all the writ petitions, the 5 writ petitions would read as in Ray 2025. The Wakf Amendment Act 2025, 1, 2, 3, 4, 5.
Obliged. Very deeply obliged.